If you were a Spider-Man fan as a kid, you probably know a web blaster, a toy which mimics Spider-Man's web shooting abilities. Inventor Stephen Kimble developed a toy that enables children to shoot foam spider webs from the palm of the hand. Kimble obtained a patent on this toy back in 1990, and it was set to expire in 2010. In December 1919, Kimble approached Marvel in hopes of selling or licensing the device. Not long time after Marvel turned down Kimble's offer, Marvel started to produce Web Blaster, a toy similar to Kimble's design. As a result, in 1997, Kimble sued Marvel for patent infringement. Parties settled in 2001. Marvel purchased patent rights from Kimble for about $500,000 and agreed to pay Kimble 3% royalties on future product sales. But even though the patent expires at a certain point, as all patents do, their agreement on royalties had no expiration date. At the time of the settling, neither side was aware of Brulotte, a doctrine which prohibits collection of any post-expiration patent royalties. In 2006, Marvel licensed the use of the patent to Hasbro Inc., allowing the company to produce the toy. And soon after that, Kimble and Marlin disagreed regarding the royalty amount that Marvel owed Kimble from toys produced by Hasbro. Kimble filed a claim that the original patent and contract were infringed. Marvel then launched a counterclaim, stating that it was not required to pay royalties beyond the expiration date of the Kimble Spider-Man toy patent.
In Kimble v. Marvel, the legal issue is whether the court should follow stare decisis and allow Brulotte v. Fizco to guide its decision here, or whether the Brulotte decision should be disregarded. In Brulotte v. Fizco, Fizco invented and licensed a patented hop picking machine to farmers in exchange for royalties from hop crops harvested both before and after the patent's expiration dates. Each machine was sold at a flat sum, and there was a license issued for its use. The license for the machine brought by Brulotte expired in 1957, and the petitioner refused to make royalty payments. The suit was to recover those royalty payments both before and after the patent expired. According to U.S. Code, the typical patent expires 20 years from the application date. At that point, the unrestricted right to make or use the article passes to the public. In 1964, the court held in an 8-1 vote the agreement was unenforceable to provide the payment of royalties accruing after the last of the patent incorporated into the machines had expired. The court held that these post-patent royalties were unlawful because they continued the monopoly to beyond the patent period. Now, in Kimble v. Marvel, the court returns to the 50-year-old ruling to determine whether the Brulotte still applies.
Justice Kagan gives her opinion, and in keeping to the Marvel theme, stated that patents endow their holders with certain superpowers, but only for a limited time. Once the patented invention term expires, usually 20 years, it becomes public property, and any attempt to limit a licensee's post-expiration use of the invention, whatever the legal device employed, runs counter to the policy and purpose of the patent laws. The Brulotte rule, like other rulings, makes certain contract provisions unenforceable and prevents some parties from entering into deals they desire. However, parties often find ways around Brulotte to achieve the same ends. One is able to defer payments for the pre-expiration use of a patent into the post-expiration period. For example, a licensee could agree to pay the licensor a higher percentage during the 20-year patent term, which is enforceable, but amortize the payment over 40 years or longer. Secondly, overruling precedent is no small matter. Stare decisis is the idea that today's court should stand by yesterday's decisions. It is a foundation stone of the rule of law. Respecting stare decisis means sticking to some wrong decisions. And a quote from a prior court ruling states, "It usually is more important that the applicable rule of law be settled than that it be settled right." A third reason for the opinion states that Congress has spurned multiple opportunities to reverse Brulat. Brulat lies at the intersection of two areas of law, namely property and contracts. Stare decisis receives a superpowered form in these cases, and we would need a super special justification to warrant reversing it. These were the words of Justice Kagan in keeping to the Marvel theme. Parties are especially likely to rely on such precedents when doing business. And since the precedent has been set, and parties may be aware of it, or should be aware of it, then there is no reason to overrule this prior precedent.
The dissent was written by Justice Alito, with whom Chief Justice Roberts and Justice Thomas joined. Their dissent was based on the idea that the Brulat rule interferes with the abilities of two parties to properly negotiate licensing agreements that reflect the true value of a product. This makes Brulat a poor interpretation of the Patent Act and leaves it with no weight as a precedent. The dissent argued that the decision was not based on anything that can be plausibly regarded as an interpretation of the terms of the Patent Act. The dissent agreed with Kimble's argument that Brulat and the decision was based on an economic theory that has been debunked. The dissent felt that a licensing agreement that provides payment of royalties after a patent term expires does not enlarge the patentee monopoly or extend the terms of the patent. According to the dissent, Brulat was thus a bold act of policymaking. It was not really a statutory interpretation at all. The dissent argues that the decision interferes with the abilities of parties to negotiate licensing agreements that reflect the true value of a patent, and having to go around Brulat is an inefficiency in itself, and the alternative arrangement would not necessarily yield the same amount of royalties. The Patent Act says nothing about how to handle post-expiration royalties. According to the dissent, stare decisis is not an inexorable command, and revisiting precedent is appropriate here. The dissent went on to explain that the precedent is based on a judge-made rule and is not grounded in anything that Congress has enacted, and thus the dissent felt it was the court's initial error in their prior decision on the Brulat case. Therefore, the courts were putting too much reliance on congressional intervention instead of overturning the past decision.
To conclude, we highlight 3 points considered in the evaluation of Kimble v. Marvel Entertainment. First, there were marked differences between the Brulat v. Theis case and the Kimble v. Marvel Entertainment case, which made the selection of Kimble v. Marvel by the Supreme Court of high interest to many. Kimble held one patent and did not produce the toys directly. His patent was licensed by Marvel, and Marvel developed and marketed the toys. In Brulat v. Theis, Theis held several patents that were all incorporated in the design of hops machines, machines that Theis produced, marketed, and sold directly. Many thought a different ruling would come from the Kimble v. Marvel Entertainment case because it was purely a patent licensing case, but the ruling in Brulat still stands. Secondly, the construction of the contracts in both of these cases would have benefited from the counsel of a law firm specializing in intellectual property law. At the time of Kimble's licensing contract with Marvel, the ruling of Brulat was well known in patent law and should have informed the format of his contract with Marvel. Patent law allows for licensing payments to be deferred until after the expiration of the patent when agreed in contract. Neither Theis nor Kimble requested a deferred payment schedule for the licensing of their patents. Also, neither contract clearly differentiated the terms for before expiration and for after expiration of the patent. This is significant, especially in Brulat, where there were multiple patents that expired at different times and where the licensing royalty payments were combined with payments required for the use of their machines. Finally, as noted earlier in this presentation, Congress has the power to overturn Brulot and legislate a policy fix, but has decided not to do so. Those who support overturning Brulot suggest that licensing deals that extend beyond the expiration of a patent will encourage innovation, allowing businesses that license patents to amortize development costs over time, keeping the end cost of products low and encouraging market competition. The Supreme Court declined Kimble's invitation to overrule Brulot. It is up to patent holders to be mindful of this ruling when entering into licensing royalty contracts.